You're out of the will! The Aristocats. Beloved, fun, a little more than vaguely racist. But we're not here to discuss the so-called problems of its time. No, we're actually here today to look at the core issue at the center of the Aristocats. Can you leave everything to your pets in your will? It's actually surprisingly common for people to leave assets to their pets in their will. However, there are some legal issues that can make such a will pretty much unenforceable or super easy to contest. I'll get into some real-world examples in a minute. However, there are some things to keep in mind if you are inspired by the Aristocats and want to leave everything to your tiny fur babies. You can't just name your pet as your heir. The way the United States legal system works, all that money and all of those assets will just go right back into your state, and sorry, Fido, you're out of luck. A better course of action is to have a designated caretaker that you bequeath the pet to. Sort of like choosing a godparent for a child. An example might be, I bequeath my dear darling Eleanor to my close and dear friend Emma. And I will also bequeath however much money that I have at the time to take care of her. Talk to an actual lawyer to get the phrasing right for your own will, if this is something you're looking into. There are other options, including one that is a little more expensive. This is called a pet trust. A pet trust effectively creates a legally binding contract with a caretaker, where if they don't uphold their end of the bargain, they're liable to be sued. It would outline proper care and maintenance of your pets, how the money you leave is supposed to be used, and what the money goes for after your pet, unfortunately, eventually passes on. Most importantly, a pet trust can actually be implemented way before you die. In the case you're ever incapacitated, it can actually be a fantastic tool to have it at the ready, just in case. You never know what will happen. Also, pet trusts are completely legal in all 50 United States. At this point, you're probably screaming at me, and you're right to. The Aristocats doesn't take place in the United States. Psh, it takes place in France. In France, you cannot leave money to a pet. In France, you cannot leave money to a pet in a will. Under French law, pets are considered property. However, you can bequeath the pet to a caretaker with instructions and conditions. This is what's known as, and I'm sorry for butchering the French language here, I do not speak French. I have attempted, it is not for me. A leg avec charge, I hope, which means a gift with responsibilities. Of course, the Aristocats does take place in 1910, so it is entirely possible that under French law this was completely legal. Unfortunately, I couldn't find any sources that could confirm or deny this. For the record, there are multiple real-world examples of people leaving a butt ton of money to their pets. A notable example, of course, is Leona Hemsley, 80s real estate mogul and noted rival of Donald Trump. She specifically allocated $12 million to go to her Maltese, Trouble. In 2008, a year after she passed, the judge decided that $12 million was way too much yuckin' money to give to a dog. So they reduced the inheritance to $2 million. As you may have guessed, Trouble was enraged. In another case, a Tennessee man named Bill Doris left $5 million to his beloved 8-year-old border collie named Lulu. In this case, which actually happened in the beginning of 2021, Lulu got all the money because Bill Doris made sure to take the time to name a caretaker. So yes, Virginia, you can in fact bequeath all of your assets to your beloved furballs. Just, you know, make sure you actually talk to a lawyer about it and figure out what you need to. Well, if you liked this, please like the video. tell me how I did. Maybe leave a comment. There's gonna be more weird stuff that I am working on. A lot of weird stuff. It's gonna be fun. I hope you choose to stick around. If you want to, please click the subscribe button, maybe. If you want. I don't know.